Good morning, everyone. Welcome to our first webinar on the Tenant Fees Act. I'm Emily Carter. I'm our Policy and Campaigns Officer here at Property Mark. And of course, a man that requires no introduction, this is David Cox, our Chief Executive.
Good morning, everybody.
This morning, we'll be covering a range of topics. Firstly, what can and can't be charged under the ban, then holding deposits and referencing, security deposits, default fees, and finally, types of tenancies covered by the ban and the transition period. I'll begin by asking David questions we gathered from the audience before the webinar and at our regional meetings, and then there will also be a chance to submit any further questions on the topics throughout the webinar. So if you have any further pressing questions that have not been answered, please make sure to submit them in the question panel. So I'll begin with a question from Kelly Smith at Allsops. David, what exactly are all of the prohibited fees under the ban?
So it's a really interesting question, actually, because that's not necessarily the best way of looking at it. So I entirely see where you're coming from, Kirsty, but sorry, not
Kelly.
Kelly. I entirely see where you're coming from, but I think what the best way of looking at the ban is everything is banned under Section 2, Clause 1, unless it is specifically a permitted payment. So probably the best way of doing this is what's allowed, and then everything else is banned. So what are the permitted payments? First one is the rent, and the second one are utility bills. Now, I think that really shows that they've had to actually make the rent and utility bills permitted payment, because otherwise they would fall foul of the ban. So number 1 and 2, rent and permitted payments. After that, the sort of main permitted payments. Number 1, a holding deposit that is capped at 1 week's rent. A security deposit that is capped at capped at 5 weeks rent, but if the rent is over £50,000 per year, it's then capped at 6 weeks rent. And the final one is the default fees. And the default fees will be lost keys or other security devices. It will be rent. Now that is also going to be, unpaid rent, so rent arrears. That will be capped at 0.75% above the Bank of England's base rate. 3% above the Bank of England's base rate, which is currently 0.75, so 3.75%. And that can be levied from the date it's due to the date it is paid. But if they pay those arrears off in the first 14 days, you can't levy the charge. So you can only levy the charge from day 14, but you can backdate it to when the rent was actually due. The other ones are any variation of contract or novation of contract, and that's capped at £50, or change of sharer, again capped at £50, or your reasonable costs if higher. I'll probably go into that in a little bit more detail in a question in a minute. And then finally, surrender of tenancy. So surrender of tenancy, if the tenant wants to get out of the property early, they will be able to charge a fee for that.
So just going back to the late rent charges, you mentioned 14 days. I've heard a few people ask this before. I'm not sure it's going to come up later, but is it 14 working days or is it 14 calendar days?
It's 14 calendar days. So all of the deadlines under the ban are in calendar days, not working days. And certainly when we get onto holding deposits, it's 15 days, which sounds like 3 working weeks, but it's actually 15 calendar days, so 2 weeks and a day. Don't ask me why they put that. 14 days would have probably been more appropriate, but that is the government.
Okay, thanks for that, David. A few attendees have mentioned referencing, so I thought we could address this first.
Yeah.
So Lynn from Hodson's would like to know if a third-party tenant referencing company can charge a tenant for a reference if the tenant has agreed to the charge.
So I think let's go through actually some of the sort of obvious fees that are gone. So admin fees are gone, application fees, setup fees, contract negotiation fees, referencing fees, inventory fees, check-ins, check-outs, renewal fees, all of those sort of standard fees that are charged, all gone. Another one that's also gone that's probably quite important is the future landlord reference, so where you charge a tenant for providing a reference to their new landlord or their new agent. You won't be able to charge the tenant any longer for that either. Looking at referencing specifically, so if we look at Section 2, subsection 2 of the ban, it makes it very clear that you cannot a third party, a referencing company, for example, cannot charge a fee that facilitates the granting of a tenancy. So what has been allowed in Scotland is an agent could say, I can't charge you fees, but go to this referencing agency and get a reference. The referencing agency then charges the tenant a fee and gives a kickback to the agent. So effectively in Scotland, they're paying basically what they were before. They're just paying it to a referencing agent and give a kickback to the agent, as opposed to paying the agent who pays the referencing agent. That has been banned in England. So what has become common practice in Scotland will not be allowed in England. There is a clause, it's actually subsection 6 of section 2, that says if a tenant chooses to pay for a service, that's acceptable. That clause is specifically designed, though, for the deposit replacement insurance schemes. So that clause looks very much at, you can either pay a 5 or a 6 week security deposit, or you can buy a deposit replacement insurance scheme. It's not designed for referencing, and I would strongly urge agents not to go down that route. You will be on a knife edge of the law, and when you think about the penalties of £5,000 for the first offence, £30,000 for the second offence, if you're getting a £25 kickback from a referencing agent, you're actually exposing yourself to a £5,000 fine potentially.
So that's really not a risk anyone should be wanting to take.
Would strongly urge agents not to do that.
Yeah, I can imagine. So David, we'll now take a couple of questions from the audience. I've had a few submitted here. Now, first of all, a question from Annabelle. She says, can we still ask them to pay for the check-in when the landlord is paying for the checkout? I understand that we cannot charge an arrangement fee for this when the ban comes in play, but what about the cost of the check-in?
I'm afraid that's a really simple one. No, check-in fees are absolutely gone. So, Annabelle, I'm really sorry, but no, you won't be able to charge check-in fee post the 1st of June.
And another question from Francis. What is the cap for surrender of tenancy?
Very good question, Francis. It's not really clear at the moment, is the honest answer. So, whilst the bill has now passed Parliament, it has received the royal assent from the Queen. All we have is the wording of the Act itself, as it now is. What we don't have yet is the official guidance published. We do have draft guidance that has been published on the parliamentary website for the last couple of months. And in that, it actually says that the tenant is liable for everything, all the rent, up to the end of the tenancy. So that is kind of where we're working on at the moment. But we're probably going to have to wait for the actual official guidance to be published. I'm hoping it will be published before our conference on the 2nd of April, and therefore we will be able to give you further updates on the later webinars closer to the ban and at our conference. But at the moment, we don't actually know the answer to that. We will, of course, as part of our tenant fees toolkit, be putting out fact sheets that will explain that to you, but at the moment I'm afraid I don't actually know the answer.
Okay, so you mentioned the government guidance there and it's still being in draft form. Have we got any idea of when that could be coming out at all?
We haven't. I spoke with the officials at the ministry last Friday. I got shortly was the answer, so I don't know. Shortly is further away than imminently, so it's not imminent yet, but it is shortly. Again, we don't have an exact date. We are pushing to get that guidance out as soon as possible so that agents have the maximum amount of time with complete regulatory certainty. But at the moment, I just don't know the answer.
Okay, thanks for that, David. I've had a question from Sarka who said, David, can you please elaborate on why the nil deposit schemes or replacement insurance for deposit is at the edge of the law?
Sorry, no, the nil deposit schemes aren't at the edge of the law.
Okay.
What I was talking about is sending a tenant off to get a reference from a referencing agent. That is almost certainly going to be illegal. The zero deposit schemes, the nil deposit schemes, they're perfectly lawful as long as there is a choice, and the choice is the important point. You can't just say you've got to go and get a deposit replacement insurance scheme. You have to say you can either pay a 5 week or 6 week security deposit, or you can use a deposit replacement insurance scheme. You have to give that choice. If you don't give the choice, the deposit replacement insurance scheme will then become a prohibited payment because it's a fee for facilitating the granting of a tenancy.
Yeah.
So as long as there is a choice, that's perfectly lawful.
So Lewis has asked whether the capped fees of £50 include VAT.
Yes, they do.
Yeah. Okay, so I hope that answers your question there, Lewis. We're just going to move on to the next topic now. So I hope you're all happy with the questions that have been answered so far. And we are now going to move on to holding deposits.
Holding deposits.
Which, of course, we've just mentioned as one of the permitted payments that can be charged. So I know this is an area that is creating quite a lot of confusion. I've got an interesting one here from Caroline at Michael Graham. If a tenant pays their holding deposit, their references come back satisfactory and they are offered the tenancy to sign, but they want to amend clauses that are not acceptable to the landlord, would they then have to return the holding deposit to the tenant?
So I think it's probably a good idea if we just go through in a little bit of detail what the holding deposits actually are. So a holding deposit can be taken to take the property off the market. It must be held for no more than 15 calendar days from the date that it's taken. It needs to be refunded if the landlord or the agent pulls out, or to the successful tenant. Now, for the successful tenant, it doesn't necessarily have to be refunded in cash. It can be given towards either the first month's rent or the security deposit. I would suggest, to avoid any issues with when the 30 days start running for the protection of the security deposit under the Housing Act, if you do put it towards one or the other, you put it towards the first month's rent, so you don't have to worry about any of the deposit protection legislation. But if you are putting it towards either the first month's rent or the security deposit, you have to get the tenant's written consent. Now, I don't think that's going to be too much of a problem. It sounds like a bit of a hurdle. It is a bit of a hurdle, but I don't think it's going to be too much of a problem.
Yeah.
What we're going to do as part of our tenant fees toolkit is provide you with a set of wording that you can use in your, whether you have an application form or a reservation form, something like that, that you get the tenant to sign, that just says at the bottom, should I become the successful tenant, my holding deposit will go towards my first month's rent. So it's a bit of a hurdle, shouldn't be too much of one though. Should be nice and easy to implement in practice. Now, when we get into the withholding of the holding deposit, it can be withheld for one of 4 reasons. Reason number 1 is if the tenant pulls out, and that's particularly as a result of what has happened in Scotland. So in Scotland, because there are no fees and there haven't been since 2012, we've had tenants going, I'll have one from you, one from you, one from you, one from you, and actually the property I'm going to take is from the chap over there.
Yeah.
That has resulted in agents going, fine, I'll take the first 5 tenants, and whichever one gets the property, gets the referencing back first, it's the tenant that gets the property. To avoid that situation in England, they've allowed holding deposits. And what they've said is if the tenant pulls out, so the tenant does, I'll have one for you, one for you, one for you, one for you, they put down 5 holding deposits, they will lose 4 of them.
Yeah.
So if the tenant pulls out, you can withhold the holding deposit. Second one, if the tenant fails a right to rent, they forfeit the holding deposit. So the government has taken the view that if you're applying to rent a property in England, you kind of know whether you have the right to live in the United Kingdom. And therefore, if you apply for a property, the agent does all the work and it turns out that you're an illegal immigrant, then you knew that beforehand, therefore you forfeit your holding deposit. So number 1, tenant pulls out. Number 2, fails the right to rent check. Number 3, so the first 2 are relatively simple. Number 3 is slightly more complicated. Number 3 is if the tenant provides a false or misleading statement.
Yeah.
Now, there's been a huge amount of debate as to what exactly false or misleading statement actually means. We argued that it meant if they failed referencing. The government have actually come down that a false or misleading statement means you have to actively lie. So the tenant has to lie in order for you to forfeit the holding deposit. So the prime example is, how much do you earn? I earn £35,000 a year. Do the referencing? Oh, no, you don't. You only earn £25,000 a year. Clearly lied.
Yeah.
Another prime example, have you got any county court judgments? No, I have no county court judgments. Do the referencing? Oh, yes, you do. You've got 3. Again, prime example, they've lied.
Yeah.
To withhold the holding deposit for the false or misleading statement, you have to be able to prove that they've lied. So what you need is some form of application form or reservation form where they're filling in the information themselves, they're signing that it's accurate at the bottom. That's also, by the way, where you put that little clause about the holding deposit going towards the first month's rent. Get them to sign it. Then you've got their information. You do the referencing. If the information is different, you can then prove that they've provided false or misleading statement. If you can't prove it, you can't withhold it. Okay? So 1, pulls out. 2, right to rent. 3, false or misleading statements. 4 is if they miss the deadline for agreement. And this is where the 15 days kick in. So what the government is expecting is that you will go from taking the holding deposit to entering the agreement, and entering the agreement is signing the contract. So both parties signing the contract. Doesn't matter when the tenancy starts, when the tenants move in, it's all about entering the agreement, signing the contract within a period of 15 calendar days. Now, if the tenant is the one that is dragging their feet, they're not getting their referencing back, their employer's being a bit late in getting their salary details to you, for example, and you pass that 15-day threshold, they forfeit the holding deposit, you can move on to the next tenant. Conversely, if the agent is the one that's not replying to emails, not done their side of it, and it hits the 15 days, you have to give that back, irrespective of whether one of the other 3 reasons for withholding it actually exist. So that's where the 15 days come from. What I would say is those 15 days can be extended by any period that is mutually agreed in writing. So both the landlord, the tenant and the agent have to agree to extend the deadline in writing, but it can be extended. And probably the prime example of why it would be extended is in situations where maybe they haven't got vacant possession of the property yet, so they don't want to sign the contract until the outgoing tenant has actually gone. So you can then extend it, but 15 days. I would also say with holding deposits, you can only take one at once. If you take a second holding deposit, that second deposit will be a prohibited payment. And secondly, if you withhold the holding deposit, you have to provide written reasons as to why you are withholding it within 7 days of the decision to withhold. So you have to provide written reasons to the tenant that they forfeited their holding deposit for this reason, and you have to do it within 7 days. Conversely as well, when you are refunding a holding deposit, you have to refund that holding deposit within a period of 7 calendar days again of the decision. So the landlord or the agent pulls out. One final one, if I may, on the false or misleading statements. If the tenant provides completely accurate information, but nonetheless fails referencing, that will be classed as the landlord or the agent pulling out, and therefore the holding deposit will have to be returned. So just failing referencing is not sufficient to trigger the false or misleading statement. There has to be an actual lie. Failing referencing and not going forward with the tenancy will be classed as the landlord or the agent pulling out.
I think that's a good clarification on that. But going back to Caroline's question, from what you've just said, I presume that they wouldn't be able to.
So I'm terribly sorry, Caroline, I've completely forgotten what question was.
So Caroline asked, if a tenant pays their holding deposit, their references come back satisfactory and they are offered the tenancy to sign, but then they want to amend a clause that is not acceptable to the landlord, would the holding deposit then have to be returned to the tenant?
So if they made a request to, so can I have a pet is probably the prime example, and the landlord declined, that would be classed as the landlord or the agent pulling out. It wouldn't fall into one of the reasons that you could withhold the holding deposit. So it's probably a good idea up front, before you've even taken the holding deposit, to see if there are any those sort of things that they want that's not part of the normal agreement, so that you don't do all the work that is involved in setting up a tenancy to then find that they come at the 11th hour with, actually I want this, because otherwise you will be the one that has to withhold the holding deposit. You won't get any money for the work that you've done.
And we've had quite a few VAT relatable questions. So a few members at one of our regional meetings have actually asked whether retained holding deposits will be classed as VAT rateable income.
So, really good question. That's something as well that isn't even in the draft guidance.
Yeah.
I don't know the answer.
Okay.
My gut reaction is that yes, it will be. But if it is not in the final guidance, what we're going to do is ask our primary authority, that is Warwickshire Trading Standards, and for property mark members,
Okay.
ALA and NAEA, it sits above all other trading standards departments in the country. It gives us assured advice on a particular topic. And then as long as our members comply with that advice, if their local trading standards takes a different view and tries to prosecute them, Warwickshire will step in and stop the prosecution.
Okay.
All members are automatically signed up to the primary authority. And so if it's not in the government guidance, what we're going to do is ask a very similar question. For holding deposits, is it VAT rateable?
Yeah.
What I would say in any event, you won't be able to take more than 1 week's holding deposit.
Yeah.
So the VAT element will come out of that. You won't be able to charge VAT on top.
Okay. Okay, thanks for that, David. We'll now see if the audience have got any further questions on holding deposits, and I've seen the screen flickering all the way through that.
Lots of questions. They're flooding in.
Hopefully we'll be able to answer some of them. So Chris has asked, if no holding deposit is taken, can we reduce the 15 days to 10?
So 15 days is a maximum. You don't have to wait till day 15.
Okay.
So it's a statutory maximum, and there's nothing wrong with, I really want this property tomorrow. Can you get it all done? And if you can, yes, you can sign the contract tomorrow. The deadline for agreement is at the statutory maximum, but if you do it on any day from 1 to 15, that's perfectly acceptable. So you don't have to wait till day 15.
Okay.
You just have to do it within a period of 15 days.
Okay, brilliant. Matthew has said, if the tenant forfeits a holding deposit, can the agent make an administration charge against it, or is it considered the landlord's money?
No, the holding deposit, this is a question that comes up a lot, actually. No, the holding deposit is the agent's. There's nothing to stop an agent saying we'll give it to the landlord, but no, the agent themselves can keep that money.
Okay, brilliant, because we had quite a few questions asking for clarification on whose money it was, the landlord.
Sorry, but yes, it's the agent's money.
David's answered that for you then. Right, so we're not far off being halfway through the webinar, and now I'll be asking David your questions on security deposits, which of course, as we discussed earlier, are capped at 5 weeks rent, unless it's over 50,000 per annum rent, where they're capped at 6 weeks rent.
Indeed.
So with a pre-existing tenancy, if a new tenancy is signed after the 1st of June 2019, will the difference have to be refunded if the agent has taken a higher deposit, for example, for a pet, on the original tenancy?
So this is a question that comes up on a massively regular basis. So security deposits, it's an interesting one. We're getting a little bit here into the transitionary provisions that we'll be coming on to later. But for new tenancies entered into, i.e. contract signed on the 1st of June this year or beyond, then it's an absolute cap of 5 weeks or 6 weeks if the rent is over £50,000. For existing tenancies, we have the transitionary provisions that we'll be coming on to later. But what those say in relation to security deposits is that whatever you've got in excess of the 5 weeks is perfectly lawful for the duration of that tenancy. So if the tenancy renews, it becomes a new tenancy, and therefore you will have to refund anything in excess of 5 weeks. But if the tenancy continues, it drops onto a statutory periodic or a contractual periodic. The guidance currently says, and I'm not expecting the guidance to change on this topic, it says that statutory and contractual periodics will continue as if they were the existing tenancy, and therefore you'll be able to retain that increase until the tenant actually moves out. But if it renews, that's where you have to refund the excess because it's a new tenancy. And if we remember our favourite case of Superstrike, the TDP case, the tenancy deposit case from 2012, it said a renewal tenancy is a new tenancy,
Yeah.
and therefore you will have to refund in excess on renewal.
Okay. And just on the topic of pets,
Pets.
I know there can be quite contentious issues with letting agents given the.
So, and the industry has traditionally taken an extra couple of weeks deposit as a pet deposit that is part of the security deposit itself. Has to be protected, and they take, you know, maybe 2 weeks to make an 8-week security deposit for a pet. That's going to be unlawful from the 1st of June. There is an absolute cap. You can't charge a higher pet deposit. Now, again, one of the questions that we've got, and I'm going to wait to see what it says in the guidance, but on my reading of the bill and the Act now, there's nothing to stop an agent charging a higher rent for a pet. So I can't see there being a problem with an agent saying, you know, the rent is £750 a month for the property, and then in the property particulars it says an extra £20 a month or an extra £10 a month rent per pet.
Okay.
Now, I don't think this actually impacts the tenant fees ban, but we have to remember the consumer protection regulations.
Yeah, of course.
And the consumer protection regulations require that an agent must make all material information available to the tenant at the earliest opportunity. And therefore, that's why I think if you're going to go down that route, you need to make sure it's in your property particulars on the portals particularly, because it has to be made at the earliest opportunity, and all material information that will allow the prospective tenant to make an informed transactional decision. Therefore, if you don't tell them until they get to the property, they've already gone to some expense of getting to the property, for example, for viewings, and therefore that's not the earliest opportunity.
Okay.
So, whilst I don't think this is a tenant fees ban issue, it is a consumer protection regulations issue. So, if you are going to do that, make sure it's very, very clear up front. Otherwise, you could be liable under the consumer protection regulations rather than the ban itself.
Yeah, brilliant. Continuing on the theme of animals and creatures, I've had quite a few questions on pest control. Could this be deducted from the security deposit, or more to the point, can the tenant be charged for it at all?
So, a couple of issues here then.
Yeah.
Number one, security deposit. The answer to that is yes, of course, absolutely. There is no changes to the way deposit deductions work under the ban. So as long as there is a clause in the tenancy agreement that says that deductions from the security deposit can be made for cleaning fleas and pest control, then of course you can take it out of the deposit. You can't, however, charge an admin fee.
Okay.
That will be a prohibited payment. So it can come out of the security deposit, but you can't charge any sort of admin fee for pest control. So yeah, it's one that will have to come out of the security deposit. This is a great moment to talk about professional cleaning, if I may.
I was going to ask you that later, but go ahead.
Let's talk cleaning. So a lot of agents, and I've seen a lot of tenancy agreements that says the property must be professionally cleaned at the end of the tenancy. Now that is actually unlawful already. The tenant fees ban isn't touching this particular aspect.
Okay.
What it is kind of doing though is highlighting things that have kind of become a norm that aren't actually lawful.
Okay.
So you can't put a clause in your tenancy agreement that says the property must be professionally cleaned at the end. That is an unfair term. It's actually been an unfair term since the Unfair Contract Terms Act of 1977.
Oh, wow.
It was then reconfirmed under the Unfair Terms in Consumer Contracts Regulations of 1999, further confirmed under the Consumer Protection from Unfair... Oh, I've just forgotten what it is. Consumer Protection Regulations from 2008. Further clarified in the guidance on the CPRs in June 2014, specifically for letting agents. And if 4 pieces of legislation wasn't enough, it was confirmed for a 5th time under Part 2 of the Consumer Rights Act 2015.
Okay.
So you cannot put into a clause in your tenancy agreement that the property must be professionally cleaned.
Yeah.
The clause needs to be the property must be returned in the condition it was at the start of the tenancy.
Okay.
which was professionally cleaned.
Yeah.
If it was professionally cleaned. If it wasn't professionally cleaned, you can't put that bit in. But if it was professionally cleaned, and that is because you could have a tenant that is a professional cleaner.
Yeah.
And therefore he or she could return the property
Yeah.
to a professional cleaning standard. Similarly, somebody that isn't a professional cleaner could clean that property to a professional standard.
Yeah.
Therefore, it is about what condition it was at the beginning of the tenancy. So agents that have got that clause, they should really amend it because it is already unlawful.
Yeah. Okay, brilliant. Thanks for that, David. I hope that's cleared a few things up for the audience, and particularly with pets and pests. I know they're quite a hot topic, and it's quite contentious, really. David, will deductions from security deposits be allowed for replacement light bulbs, mattress protectors, and smoke alarm batteries at the end of the tenancy?
Once again, it's not, the ban doesn't affect the security deposit.
Yeah.
So as long as you've got it in your tenancy agreement that those items can be deducted from the security deposit, then that should be absolutely fine. What I would say is, we've talked about pests, light bulbs, smoke alarms. I don't think you need to literally list each and every single one of them. I think what you can do is a sort of catch-all clause of it must be returned in the condition it was provided. And missing items, damaged items can be deducted. At which point, if you look in the existing ALA tenancy agreement, or Property Mark tenancy agreement, I should say, it's got that kind of catch-all clause. It's about clause 6.3. I know it's 0.3 of the deposit clause. I just can't quite remember exactly which point the deposit clause is. One of the things we're going to be doing is updating the tenancy agreement over the next month or so that it is compliant with the fees ban. But what you can do for Property Mark members, whether you are or NAA or both, you can download the tenancy agreement for free.
Yeah.
So if you're not sure about how to word those clauses, look at those, download it, even if you don't use it, download it so that you can actually lift the necessary wording.
Yeah. Brilliant. Thanks for that, David. And finally, our last question on this topic. Liz from Agent Smart has asked if the prescribed information and deposit certificates would need to be reissued to the tenants if part of a deposit has been refunded.
Right.
And I've had quite a few people asking the same question up here as well.
Good question. Don't know is the honest answer at this point in time. Now, one of the things we are doing is we are working with the deposit schemes at the moment to work out how to do this administratively, because it's really only going to be on renewal tenancies, but there's potentially going to be millions of renewal tenancies coming after the ban comes into force. So we don't know yet. Now, it's probably going to be slightly easier if you're using an insured scheme because you've got the money. You can then refund the money quite easily. Do you need to deprotect, reprotect, reserve the prescribed information? I don't know at the moment.
Okay.
What I'm hoping is, again, we will be able to make an announcement on that topic at our conference. Certainly, the argument that I have made to officials in the department is that the administrative requirements of doing that are going to be massive. It is why, let's go back to Super Strike. Super Strike required us all to do that in 2012. The government said that was not the spirit of the legislation. That was not what we intended when we passed the Housing Act 2004. Therefore, when they passed the Deregulation Act of 2015, they overrode the court's decision. So that, I'm sure we all remember that, we were serving prescribed information right, left and centre, and then we didn't have to do it any longer. So the government has already reversed that once. It would surprise me if they then put it back again. But then nothing really surprises me with government. So it's possible, but we have certainly made strong representations that they shouldn't have to do it. I'm hoping there will be a definitive answer in the guidance, but just in case there's not, we are working with the deposit scheme to work out how they can do it administratively, so that agents are not spending hours deprotecting, reprotecting, reissuing. It's going to be more difficult in the custodial schemes because the agent doesn't have the money. Therefore, is there a system, and we are looking at a couple of options at this point in time, of what we can do about custodial deposits. So I don't have the answer yet, but what I would say, come to our conference and hopefully we'll be able to give you an answer there. We should be able to give you an answer there.
Yeah.
Otherwise, the next webinar should give you the definitive answer on that.
Okay, brilliant. Thanks for that, David. I'm going to move on to the next topic because I think we've covered most things on this topic that are popping up in the question panel there. So I'm going to go into default fees, which I'm seeing questions popping up here,
fees.
but we'll answer them in a minute, I promise. So I know they were very briefly mentioned in the first part of the webinar. So if anyone has got any other questions, please submit them because I know that it can be a bit confusing. But first, Kate from Murray Management wants to know if tenants can be charged for a contractor call out for things where the tenant has caused damage, such as a drain that has been blocked by hair or fat.
I always get a little bit pilloried when I answer this question because the answer, I'm afraid, is no. No, you won't. It's actually something that has changed as the bill has gone through Parliament.
Okay.
So in the draft bill and in the bill that was introduced to Parliament, the bill that passed the House of Commons, it was allowed. But when we got into the House of Lords, they restricted the default fees to just lost keys and other security devices, rent arrears, change of sharer, novation of contract and variation of contract, and surrender of tenancy. So what was allowed is now not going to be allowed. So you're not going to be able to charge. You're not going to be able to charge for contractors as a result of the tenant doing something that they shouldn't have done. You're also not going to be able to charge or at least levy a fee for miscontractor appointments. So if the tenant says, yes, I'll be there to let the gas safety engineer in to do the gas safety certificate, and then they don't turn up or they don't let them in, you're not going to be able to charge for that miscontractor appointment. What you will do, and once again, comes back to the deposit clause.
Okay.
You will be able to deduct those costs from the deposit, provided it is allowable within your deposit clause, number one. Number two, you will also be able to take the tenant to court to recover those. So you will be able to make a damages claim in the court. I am sure there are 700 eyes rolling at this moment in time on the webinar going, never going to happen, which I do accept. The likelihood of being, well, you'll be successful in court because the tenant caused it. It will be quite easy to prove it. Trying to get a money order out of a tenant, we all know is nigh on impossible. It's why we all use section 21 rather than section 8. So you can go to court, but I would suggest the easier one is to try and deduct it from the deposit.
Okay, so I was actually going to ask you a few questions on end of tenancy cleaning, but you've already answered those.
Sorry.
Thank you for that, David. This one is from Tina at Harris Lamb, and she says, if a tenant won't allow access to a contractor and the landlord keeps being charged for the call out, can this charge be passed on to the tenant? I'm not sure if that fits into the last question. I think that fits
into the last question. So no, I'm afraid, Tina, you won't, but you will again deduct from the deposit or take the tenant to court.
Okay, I'm going to take a couple of questions from the audience that have just been submitted. So if you just bear with me a second while I just try and find one that's actually related to what we're talking about at this moment in time. So Juliet has asked, to charge for the contractor's invoice, is this different to an admin fee?
No, sorry. Whether it's a contractor invoice or an admin fee that you levy, you won't be able to charge it. So it will have to come out of the deposit at the end of the tenancy, I'm afraid. I know that's not the answer. We've argued very strongly that that should be allowed. And it was. It was even in some of the earlier drafts of the guidance. And actually, I say earlier draft, it actually was still allowed in the draft government guidance. But unfortunately, the draft government guidance was on the parliamentary website, was issued before they made the changes limiting default fees. So I'm afraid, no, you won't be able to do that.
See, I've got an interesting question from Harry here, which may or may not seem obvious, but he says, if agents can't charge default fees, can landlords charge them directly instead, e.g. miscontractors appointments? Because I feel a lot of people often think that the ban only applies to letting agents, but of course you'll explain that now.
Absolutely, that is a great question. Love the idea. No, I'm afraid we talk about the letting fees ban, but it's actually the Tenant Fees Act. It doesn't just apply to letting agents. So it bans letting agents, obviously, from charging fees. It also bans landlords from charging fees. And as we discussed earlier with the example of tenant referencing, it bans third parties from charging fees. So no, you can't just get the landlord to invoice the tenant, because then, well, technically then both of you will be breaching the ban and both of you will be liable for the fine.
Okay, I've had another question from another David, and
Hi.
he has asked, can we have a definitive full list of default fees nearer the time, something we could have in the property market AST?
Good question, David. So, forgot about that one. Yeah, excellent. So, default fees, they have to be written into the tenancy agreement. So, unless they are written into the tenancy agreement, you can't charge them later. So, one, all default fees must be written into the tenancy agreement. Under the Consumer Rights Act, you must also make sure, under the Consumer Rights Act, you must also make sure that any default fees that are in your tenancy agreement are also on your fee schedules, that you must prominently display in your office and on your website. And from the 1st of June, when this comes in, you must also prominently display them on all third-party websites that you use. Portals, Rightmove, Zoopla on the market being the obvious ones. But if you advertise on Facebook, if you advertise on LinkedIn, even if you advertise on Twitter, and don't ask me how you're going to get this in the 280 characters, but even if you advertise your properties on Twitter, you have to get your fees in there as well. I'm assuming a link will be fine, because in 280 characters, you're probably not going to be able to put all your fees. And certainly they're not a property as well. So you will have to display your fees, so default fees on in your tenancy agreement, on your fee schedule that is in your office, on your website, and on any third-party website. In terms of the property mark agreement, yes, those are all going into the property mark agreement. We are drafting it at the moment. What we are also drafting is a template fee schedule. So for Arla members, you've already had access to the template fee schedules for the last few years, since 2015. We are updating them at the moment. In fact, it was something I was doing over the weekend. Because the tenant fees are now going to be so prescriptive, we're actually going to be producing one that you don't need to edit. You can just stick on your wall, because they are what they are. So everybody is going to have to charge the same. There's not like the current fee schedules where you can edit them, because they are so prescriptive about what can be charged. So that is going to be launched as part of the Tenant Fees Toolkit at Arla Conference on the 2nd of April. Hopefully by that point in time, we will have the guidance. So we've kind of drafted them, and literally over the weekend, I was drafting them on what I expect the final guidance to say. I'm hoping that we will have the final guidance before Arla Conference, so that I can double check that I'm right, and then we can publish them from Arla Conference Day. Interestingly, whilst we're talking about fees, so you're going to love this one. You're not going to need one fee schedule. You're going to need two. So the ban, as we're going to come on to in a minute, only applies to assured short hold tenancy agreements entered into on or after the 1st of June. But you still, this year, 2019. But you're still going to have fees associated with existing tenancies for the next 12 months. So you're going to need two fee schedules. You're going to need one for your new tenancies on or after the 1st of June, and then you're going to need another one for your existing fees. Let's make this slightly more complicated as well now. It only covers assured short hold tenancy agreements. So if you are letting on assured tenancies, you're then going to need a further fee schedule for assured tenancies and the fees associated with assured tenancy in order to comply with the Consumer Rights Act. So what we are producing at the moment is a new one for new tenancies that won't be editable because it's so prescribed, and then a second one that will be editable for existing tenancies and all assured tenancies now are going forward. So hope you've got plenty of wall space, but that's where we are.
Okay, I've got time for one final question on default fees, and also an interesting one from Jessica here. I know you mentioned earlier that a lost key or respective security device is stipulated as one of the default fees, but Jessica wants to know if the fee for lost keys essentially is just the cost of the locksmith, or is there a cap to this fee?
Good question. So, I'm afraid it's another one of these where we're going to have to wait for the guidance. So what you will definitely be able to charge for is the replacement cost of the key, the actual key itself.
Yeah.
So I actually use where I live as a prime example. If I lose the key fob to my apartment block to get a new key fob, that's £60.
Yeah.
You will be able to charge that. If I lose the buzzer thing for the car park, they bill us £100.
Yeah.
So you will be able to charge that. For most sort of standard keys, it will be the cost of the £5 that it costs for the replacement key.
Okay.
If you need a locksmith, it's not really clear on the face of the bill at the moment as to whether or not you'll be able to bill for the locksmith.
Yeah.
I assume you will, but I don't know yet. We're going to wait for the government guidance.
Okay.
What we don't know yet is whether or not you'll be able to bill for your time. So, getting a locksmith, doing all the preparation, especially if you've got to go to the property, probably talking a couple of hours work. Will you be able to bill for your time in that? At the moment, we don't know. I'm hoping the government guidance will make that clear.
Okay.
But at the moment, definitely the actual replacement.
Yeah.
Whether the locksmith, questionable, but probably. Time, I'm afraid I don't know at this point in time. I don't know which way they're going to come down on it.
Okay, Graham wants to know if you can charge more than £50 for a tenant changeover if we can prove so, i.e. hourly rate, and how would we do this?
So, that actually is very similar to the last one. So, a couple of points there, Graham. One, yes, you can charge more than £50. What the legislation says is £50 or your reasonable costs if higher. Now, you made the absolute point, you will have to be able to prove that your reasonable costs are higher. The question comes is whether or not you can charge your time. Because in something like a change of sharer, what you're going to have is, it's your time.
Yeah, of course.
Research within Arla members suggested that on average, it takes about 8 hours to do all the paperwork, all the chasing, etc., etc. Now, will you be able to charge for that? I don't know. We've certainly advocated that they should be able to charge for that, because they're not doing it because they want to do it. They're doing it because the tenant has specifically requested it. Therefore, it's a breach of contract. It's an absolute default. Therefore, they should be able to charge their reasonable costs. It's something that's interesting in the guidance. So in the current guidance, the one that is the draft version that's on the parliamentary website, it says you're not allowed.
Yeah.
But some of the earlier versions, it was allowed in.
Okay.
So we don't know which way the government is going to come down on it. It's going to come down to a ministerial decision in the next few weeks. So as soon as we know, we will let you know.
Okay.
What I would say is, this kind of the end of Graham's question was about how do we evidence our hourly rate?
Yeah, of course.
What I'm expecting, if they do allow it, is that the government will actually set out a kind of formula in the regulations. In the guidance.
Yeah.
Which I think the Office of National Statistics holds the average hourly rate for kind of every profession. And whilst I can't remember the exact figure at this point in time, because it's £15 and something an hour. I want to say £15.63 an hour, but please don't quote me. It's somewhere between £15 and £16 an hour.
Okay.
So what I'm expecting is that for something like a change of sharer, they will, if they allow agents to charge their time, what they will probably say is you can charge up to X number of hours.
Yeah.
Probably won't go up to 8, maybe 4.
Okay.
At the ONS's average rate for an agent, which is £15 an hour. So that's how you will calculate it.
Okay.
If they allow time in the guidance but don't give a formula, that's another thing that we can ask the primary authority to what should agents do, how should this be dealt with. So hopefully we will be able to get you some sort of regulatory certainty, but at the moment I don't know.
Okay, so I hope that answered your question there, Graham. We're reaching the end of the webinar now, but as a final topic, we'll run through types of tenancy that come under the ban and the transition period within the Tenant Fees Act. David, of all the topics, this has been the most popular, so hopefully we'll be able to answer all of the questions that have been submitted. Firstly, I'm going to start with Daniel on Twitter, who asked whether the ban will impact the fees being charged on short-term let websites, which it would be great if you could address along with what sort of tenancies actually fall under the legislation.
Absolutely. So, what tenancies fall under the legislation? One, Daniel, I'm afraid short-term lets don't. So, there's only two types of tenancies that actually fall under the ban. One, assured short-hold tenancies. And two, licenses to occupy.
Okay.
So, a few things to remember on this one, particularly for our central London colleagues who may be watching. If the annual aggregate rent on the property is over £100,000 a year, that is no longer an assured short-hold tenancy.
Okay.
So you can continue charging fees. It's a non-housing act tenancy. Any other type of non-housing act tenancy, so Rent Act tenancies, secure tenancies, regulated tenancies, Rent Agriculture Act tenancies, all of those outside of the ban. Big one, company lets. Company let is a non-housing act tenancy, therefore you can still charge fees on company lets.
Okay.
What I would also say is actually the Consumer Rights Act and the displaying of fees, you only need to display the fees associated with assured tenancies and licenses to occupy.
Okay.
So you don't need to put your company let fees and things like that on your fee schedules.
Brilliant.
So it's only ASTs and it's only licenses to occupy.
Okay.
What I would say quickly on the company let one, whilst the company let is a non-housing act tenancy and you can charge the company whatever you want, that is a business to business transaction.
Yeah.
And this is business to consumer legislation. Some companies, not many, but some companies then charge their member of staff some form of admin fee to move into the property. Now, the company has a non-housing act tenancy with the agent, but they are issuing a license to occupy to their member of staff. The license to occupy is covered by the ban, therefore they will be in breach of the ban if they charge an admin fee to their member of staff moving into the property. So if you are doing company lets, it's probably a good idea to remind the company that they cannot charge any sort of fees or admin to their member of staff for moving into the property once the ban comes into force.
Okay, brilliant. Thanks for clearing that up, David. Just to go back on the topic as a whole, could you just run through the transition period of the ban, please?
Transition period. So, it's probably a relatively new concept because we haven't had to deal with transitionary periods in most housing law. But every piece of legislation that comes out of Parliament has what are known as transitionary provision. That is because an Act of Parliament starts on a day. It comes into force. For us, D-Day is the 1st of June this year. And therefore, all new tenancies entered into, which is contract signed, entered into on or after the 1st of June, the fee ban kicks in. But there are going to be millions of tenancies out there that are in existence on the 1st of June.
Of course.
So they have to put in what are known as transitionary provisions to deal with those existing tenancies. And what they are is, one, the ban is not retrospective. It only applies to new tenancies entered into on or after the 1st of June. For those existing tenancies, you can still charge any fees associated with that tenancy for a period of 12 months.
Okay.
I.e. up to and including 31st of May 2020.
Yeah.
That seems relatively simple. It's not. So, if the tenancy renews, that is a new tenancy. All fees drop off at that moment in time.
Okay.
If the tenancy drops onto a statutory periodic or a contractual periodic, that is classed as the continuation of the existing tenancy.
Okay.
Therefore, that should be fine. Fees should be chargeable up to 31st of May next year. Let's make it slightly more complicated. During that transition period, you can only charge fees associated with the tenancy if they are written into the tenancy agreement.
Okay.
Now, a lot of fees are already written into the tenancy agreement. a lot of agents write all their fees into their tenancy agreement.
Yeah.
If you don't, and they're only on your fee schedule, you're not going to be able to charge them.
Okay.
Therefore, again, one of the things we are putting together as part of the tenant fees toolkit is a standard variation of contract that will transfer all the fees in the fee schedule into the AST.
Yeah.
Again, we're going to be launching that hopefully at our conference in a few weeks' time, with the caveat that the guidance has been published. But what agents will then be able to do is get the tenant to sign that all fees that are on their fee schedule go into their tenancy agreement, if you haven't got them already.
Okay, this is quite a good one from Stephanie, because I've heard this a few times. She wants to know if an addendum sheet is classified as a renewal.
An addendum sheet.
An addendum, so if you add it onto the tenancy.
It depends what she actually means. So if she means a kind of variation, so like the fee clause going in, that is a variation. It won't be a new contract. If she's talking about signing a new tenancy agreement, then that is a new contract, and the fee ban will come in. One of the things that is particularly relevant on this one is the renewal fees. Renewal fees should be chargeable as long as it is clear that they are associated with the existing tenancy. And I would say it should be chargeable during the transition period. As long as it is clear in the tenancy agreement that they are associated with the existing tenancy, they are not part of the new tenancy. So I suppose the way to think about this is the ban is kind of a step. You lose on the 1st of June all new tenancies, and then on the 1st of June next year, you lose it for all existing tenancies that are still ongoing. But have to be in the tenancy agreement, have to be on your fee schedules, and if they're not in the tenancy agreement yet, you're going to have to get that clause to move them into the tenancy agreement. Otherwise, you won't be able to charge them. Okay,
I hope that answered your question there, Stephanie. I've just got one final question on
these topics.
Wind it up. Gary at Beresford wants to know if an existing tenancy renews between the 1st of June 2019 and the 1st of June 2020, have the checkout fees charged at the start of the tenancy got to be refunded?
Yes. So, really important point. Great question from Gary there. So, if you've taken the checkout fees at the start of the tenancy, if the tenancy ends during the transition period, that's fine. If the tenancy renews during the transition period, what you've got then is a prohibited payment, because the checkout fee is associated with the end of the tenancy, and the tenancy is renewed, it's a new tenancy. Therefore, that checkout fee automatically becomes a prohibited payment, and you have to refund it within 7 days, calendar days.
Okay, brilliant. I've just got one final question, which is aside from the Tenant Fees Act itself. I thought it was a really interesting one. It's from Wilt at LHH Residential, and he wants to know about how legislative change in the private rented sector will impact the country as a whole. He says, can we expect the European norm of letting property unfurnished and without white goods as a common practice in the UK in years to come?
I think that's a really interesting question. Possibly. If you think we want longer term tenancies, we want rent control. In Germany, they have indefinite tenancies and they have rent control. Well, yes, both of these things are true. They do have indefinite tenancies. They do have rent control. But in most parts of Germany, and I do accept in certain cities this has been reduced, but in most parts of Germany, rent control is you're not allowed to put the rent up by more than 20% every 3 years. I'm sure there's many people watching this webinar, they're going, okay, I can accept that sort of rent control. 20% in 3 years. And they have indefinite tenancies because there are no repairing obligations on the part of the landlord. They provide a shell. In Germany and France, that shell does need to be watertight. It requires windows and doors. In Bulgaria and Romania, windows and doors are optional. But in Germany, France, they don't come with kitchens, let alone white goods. Kitchens, bathrooms. The tenant is responsible for fitting out the kitchen, fitting out the bathroom, and maintaining the property during the tenancy. Now, what I have said to government many, many times, I've said it before parliamentary committees and in numerous speeches, is if you want to move to a German-style rental market, you can't just pick the best bits. In this country, we've spent 30 years working on property standards, and we hear every day in the press about property standards must be better.
Yeah.
So they've given shorter tenancies and no rent control in this country, but massively cracked down on landlords in terms of property conditions. Whereas in Germany, they've taken the opposite view and given greater security of tenure, rent control in the loosest possible form. But repairing, that's up to the tenant. You're the one that's living in it. If it breaks, fix it. So what do we want? I would say the system we've got is probably better.
Yeah.
But they can't just cherry pick the best bits from every area.
Yeah, of course.
So it is a brilliant question. I don't know which way we're going. And it's actually kind of going to depend on the government of the day.
Yeah.
And what political persuasion the government of the day may be. Labour is much keener on rent controls than the Conservatives. But that is where we are.
Okay, thanks for that, David. That's about all we have time for today. I'm sorry if anyone hasn't been able to have their questions answered, but we are currently producing a tenant fees FAQ, which David mentioned, in our tenant fees toolkit, which will be available soon. So please get in touch with us if there's anything you're still unsure on. Of course, we'll be sending out the recording of this webinar shortly. We look forward to seeing some of you at the Isle of Property Mark National Conference and Exhibition in April.
Yep.
Thank you for watching.
Thank you very much.
Bye.
Goodbye.